Well, I am here to discuss the best practices to maintain your business entity and to protect it, protect your personal assets, and to also think about planning and growth and things along those lines. My area of practice is commercial litigation, bankruptcy, out-of-court workouts, and corporate and transactional work. And you'd be surprised, but a lot of it meshes. And I'd like to just see, though, a show of hands, how many of y'all have your own entity, be it a corporation, partnership, limited partnership? Good. Well, I assume that one of the reasons why you created this entity was to protect yourself from personal liability. Show of hands, was that an issue that you considered? Well, it's a good issue, and I strongly encourage it. Now, I want to, there are a lot of reasons, other reasons why people choose a specific entity. The one thing I want to tell you, though, is yes, forming an entity protects you from contractual liability, but it doesn't protect you from fraud. So if you're going, if you or someone that you're dealing with has made a misrepresentation of some sort, the fact that they have created an entity doesn't necessarily protect them. Certainly you can sue the entity for breach of contract and fraud, but you can also sue the individual. When you choose an entity, it's important, one, to have a relationship with an accountant. One, because there are tax reasons why you may choose one entity over another. But you also want to look at your business purpose, whether or not you have other owners involved, whether or not you have silent investors involved, or you plan on having silent investors who want to be more passive investors and really don't want to be involved in the management and operation of the entity. So you want to look at who's going to manage it. The length of the venture. There are many ventures that you only want to last for 3 or 4 years, and then you want an exit strategy. I can tell you this, if you're going to have a fellow, what I'll call partner, you need to have these discussions going in so that everyone has an expectation. And many times you want to get this in writing. Now, as part of the workbook that we've handed out, I've got an outline in there, and hopefully it'll be a valuable resource for you. I'm not going to go by that outline. My goal here today is to arm you with enough information to make you dangerous, to make you aware of potential issues so that you consult with your attorney or your lawyer as to what you can do, what you can't do. From an overall viewpoint, things are always great when you're making money and you've got enough, and your company has enough money to pay its debts. Where the problems generally arise is when your company isn't making enough money and you're juggling things. And then people do stupid things when that happens, and sometimes end up converting what I'll call corporate liability into individual liability. And before I discuss the entities, I'll give an example. I had a client that actually represented in bankruptcy, but he had an employee who got injured on the job, broke his neck. Thank God it wasn't, believe it or not, serious. I mean, he ended up, he's walking, he's not paralyzed or anything like this, but he didn't have workers' comp. So he started moving assets around. The employee first sued for personal injury. When the employee's attorney found out that assets were being moved around, he also filed fraudulent conveyance actions against the owner. Well, they first tried the personal injury action, and the employee was awarded about $650,000 in damages. Then they tried the fraudulent conveyance action, because the judge said, I don't want to hear the fraudulent conveyance action until I know whether or not this employee has a claim. Jury came back with over $1 million award. Guy had to file bankruptcy. and a plan was filed. But that's what can happen when you start taking desperate actions. And so, again, my goal, and Steve may talk about this as well, is trying to keep you out of trouble. Because once you form that entity, you want to protect not only your business entity, but you also want to protect your personal assets. So, let's talk about corporations. Generally speaking, there are three types of corporations. You got the C Corp, the S Corp, and the closed corporation. The C Corp is your regular corporation, and if you've heard about, well, one of the problems with C Corps is the double taxation issue. What do I mean by that? Well, the double taxation issue is corporation pays taxes on its profits, and then to the extent it's distributed as dividends, then the shareholder pays a tax. So sometimes what is done, and through the IRS you can make the election, the subchapter S election, where the shareholders basically absorb the taxes of the corporation. And so it flows from the corporation to the shareholders. So now, there are times that you want a C corporation. One of the limitations of an S corporation is you cannot have more than 100 shareholders. So it's focused on what I'll call small to medium-sized businesses. When you form a corporation, you file articles of incorporation with the Secretary of State. You also have bylaws. Bylaws are what I like to call the constitution of the corporation. It sets forth the responsibilities and obligations of the board of directors, officers, and even the shareholders. There are many times that I encourage, and then you also have organizational minutes, where the board approves a number of basic actions. So when you go to a lawyer and you ask him or her to form a corporation, generally what you should get out of it is articles of incorporation, bylaws, and organizational minutes. So from there, what you need to do then is just respect the entity. And you're going to hear me say that a number of times. When you don't respect the corporation, that's when you have problems. There's also a closed corporation, where basically it's managed by shareholders and there are no officers. You don't see many of those, but to the extent there's shareholder involvement and all the shareholders want to be involved in some way, shape, or form, you can have a closed corporation. The other thing that doesn't really come into the corporate packet, but I think is necessary, is a buy-sell agreement. And the reason why I say that is it's all part of the exit strategy. Especially if you've got a fellow shareholder or a group of shareholders. What happens when that shareholder wants to sell his or her interest? How do you deal with that? Well, generally in the buy-sell, you have a right of first refusal, giving other shareholders the right to buy your interest. But there also, the buy-sell will generally deal with disability, death, and divorce. Not many of you, I think, would really want your partner's angry spouse to become a shareholder in your company, right? So, you choose your partners. You don't want the court choosing your partner. So many times, you deal with the divorce issue as well. And keep in mind, when you're dealing with the disposition of what arguably is community property, to make the buy-sell agreement enforceable, the spouse, I say the wife, the spouse has to sign the buy-sell agreement and has to be represented by independent counsel. If you don't have that, it's generally not going to be enforceable. And I have clients say, there is no way I can get my wife to sign this buy-sell agreement. And what I tell my clients is, hey, darling, we're not getting a divorce, but I want to make sure my partner doesn't get a divorce and we're dealing with an angry spouse. So I would say this, though, more often than not, client doesn't want to spend the money on a buy-sell. But that's your exit strategy. That's part of your exit strategy that you really need to think about if you've got a partner. And I use partner generically during this talk. because you don't want to deal with the issue if your partner dies, is disabled, and can no longer work. And many times these buy-sell agreements are funded by insurance. And it's an inexpensive way to deal with it, where then you're not draining cash out to pay a spouse whose husband or wife has passed away. And many times that life insurance policy has more value than the actual interest in the company. The other thing I want to stress with you, and this not only relates to corporations but partnerships and LLCs, which I'll discuss, is you want to deal with what I call the minority discount valuation issue. Because if you have less than 51% of the company, the value of your interest in that company is going to be significantly less because you don't have control. So what the courts are basically saying is that when you have an agreement that deals with the disposition of your interest, you want to address that minority discount issue where it won't necessarily apply so that you can get fair valuation out of it. And that applies to any agreement regarding ownership of an interest in a company. There's also limited liability companies. Limited liabilities are formed very similarly to corporations. Instead of articles of incorporation, you have articles of organization. Instead of bylaws, you have regulations. Instead of shareholders, you have members. Instead of shares of stock, you have units of stock. In an LLC, you decide in your articles of organization, is it going to be member-run or managed run? Some people, it doesn't matter. Generally, I'll see the managed run, where then you have you have president, secretary, vice president, so on and forth, if you want. It depends how involved the rest of the members want to be in terms of whether you want it managed or member run. There's also what's called series LLCs, which basically create different members and managers for each business purpose. Kind of like you would deal with a subsidiary of a corporation. Be careful, though, because if you're doing business in other states, make sure that those states recognize series LLCs. It was interesting. I was on a webinar about a month ago, and there was some discussion of series LLCs. And a question was posed of how many attorneys actually recommend series LLCs, and it was very few. But it's a new concept, but just be wary. It used to be when LLCs were new, attorneys were saying, be careful, because if a state hasn't implemented an LLC, then there may be some issues. The neat thing about an LLC is a taxation issue, because LLCs can elect to be either treated for tax purposes as a corporation or a partnership. So, more often than not, an LLC is created to be taxed as a partnership. Well, you might say, so big deal, what's the difference? One, I would encourage you to talk to an accountant, but for me, the primary difference is, whereas in a corporation, if you own 25% of a corporation, then you can utilize 25% of the tax attributes. And when you're an S corporation, that's what you want to utilize is the tax attributes. You know, those NOLs that you can offset some of the taxes you pay. Well, an LLC, the neat thing about an LLC is, okay, you may have someone who owns 25% of the company, but maybe put in 60% of the money, because you're the person who, you know, manages it. You're doing and your contribution is sweat equity. Well, that investor may want to utilize more of the tax attributes more than the interest that he or she owns in the LLC. So it's a very flexible entity from a taxation standpoint. And sometimes people will form an LLC in lieu of forming a limited partnership or a partnership. The first type of partnership is a general partnership. It's frowned upon because partners are liable for the debts of the partnership. They're jointly and severally liable. Now, I guess you could form a corporation, become a general partner, so that can insulate you, but you don't see many general partnerships. kind of a form of limited partnership is also a joint venture. Joint ventures, your venture partners are basically partners. A joint venture is usually for a limited period of time. But partnerships are formed with partnership agreements, hopefully. Do not do something, an oral agreement. I would not recommend that. That's when litigation evolves. A more common partnership is a limited partnership, where you have a general partner and limited partners. Now, a general partner can be a limited partner as well. General partners will hold 1 or 2% of the company, and general partners, by their nature, are liable for the debts of the limited partnership. Many times what you'll see is, because of that, if you want to be a general partner, you'll form a corporation or an LLC to be that general partner. And you manage the company, whereas limited partners are not liable. Well, they're not liable because they don't take part in the management and operation of the company. They are not liable. They are passive investors. Limited partnerships are great if you're looking to raise money. If you're looking to raise money and you don't want your investors to really be that involved in the partnership and in managing it, it's a great way to deal with that issue. Now, limited partners do have some rights, but they're very limited. Why? Because they're not liable as well. They're not liable, they're not involved in the management and operation. And again, the owner of a corporate general partner can also be a limited partner. For estate planning purposes, you'll see family limited partnerships. It's a great way to control assets and asset disposition. You also see registered limited liability partnerships. For an extra $200 a year, you can register your limited partnership as a registered limited, as an LLP. And in that, partners are not liable, even the general partner is not liable for the debts of the partnership. Even in these partnership agreements, and again, in a limited partnership, you file a certificate with the Secretary of State. Even with whether it's a partnership agreement or a buy-sell agreement, you generally want to discuss, what it takes to, for an exit strategy. You may still want to deal with some of those issues. If I want to sell my limited partnership interest, what do I need to do? Those are discussions you need to have with your fellow partners before you even get in. Sometimes the partnership's already formed, but what's your exit strategy? And be wary of that minority discount. You want to protect yourself. You want the value of your interest to be the value of the company and not be discounted because you have no control over the company. You want to discuss, and again, when you get involved in these partnerships, just have an expectation level and a meeting of minds of what it takes to have a successful partnership. Most limited partners, they don't want to be in forever. So you don't want to have disgruntled limited partners. I'm going to try to go, as we go through this, I'm going to try to go down this list that's in your workbook. And one of the questions is, what are the potential consequences if owners fail to observe regulatory requirements? How many of you all heard of piercing the corporate veil? Yeah. You're going to hear me say this over and over again. But if you don't respect the corporate entity and you start taking funds out and especially not paying the bills, and you're very lackadaisical about it, as difficult as it may be to pierce the corporate veil, you don't want some plaintiff's attorney representing a creditor of the corporation which may not have much in assets to have an opportunity to sue you individually. You generally want to do what's best for the corporation and respect that entity. Another interesting issue is you got to pay your franchise taxes. One of the easiest ways to lose your franchise, your corporate franchise, is by not paying your franchise tax. And you generally should get notice. But sometimes people move, so they don't get the notice. They don't update their articles of incorporation. With that in mind, I represented a client that really got tooled around by this company. And like within like 4 or 5 months, was owed about $250,000. Company ended up going out of business. And when we talked, I made reference to the fact that, well, you may get a judgment, but it may not be worth the paper it's written on. I don't know how many times, if you've ever met with a lawyer who's told you that, but when you consider suing someone or an entity, that's one of the issues you want to explore, is what am I going to get at the end of the day as opposed to a paper judgment. But in any event, I got online to get some information about this entity, and believe it or not, they lost their corporate franchise prior to incurring all this debt to my client. So guess what I did? I sued the officers and directors of that company. By God, we settled that. And my client got about 90% of what we were suing for. So be wary of losing your charter. You lose your charter, you're operating as a sole proprietorship, and you're responsible for the debts of the company. And it's during that time period where those debts were incurred that you lost your corporate charter. What key steps must a business protect to retain your company status? The main thing is pay the franchise tax if you have to. Again, respect that entity. Don't, sometimes people have many corporations. And so they start moving money around. Or they have one common bank account. Keep separate bank accounts for every entity. And if there are funds being transferred, you want to document that. People don't want to do that, though. They got to hire a lawyer, or they got to create a note. But then if you create a note, a promissory note, you got to follow it. But again, things always are great when you're making money. But when things get tough, that's when you really have to be careful. Within a corporation, maintain your minutes. Now, the good news is if you don't maintain your minutes, how much time do I have left? 10 minutes. If you don't maintain your corporate entity, I can't see that far. It used to be if you didn't maintain your corporate minutes, it was an indicia of piercing the corporate veil. No longer, thank God. But if you're going to do something outside the ordinary course of business, do special minutes and do annual minutes where you elect your officers and directors. The next question is, what measures should companies take for orderly transition and growth of the business? Again, I mentioned the buy-sell agreement. Talk about an exit strategy with your fellow partners. What is it? I mean, do you want to start a business and sell it in 5 years? A lot of companies consider, being part of a roll-up. I had one client whose exit strategy was, I want this larger company to buy me up. And he got some money and he got stock into the new company. The one thing I'm kind of weary about roll-ups is if you're the last person in. You kind of want to be the first person in. Not to say all roll-ups are bad. In fact, my client actually was one of the later people, and he's doing great. He's happy. But it was a discussion I had with him. He knew the owner. He had every bit of confidence in the owner. Be wary also, or at least discuss with your partner about employing family members. That can create a lot of issues in your company. And I've seen companies that go bankrupt where, it was first started by 2 brothers. And then these brothers had families. And everyone wanted to be an employee of that company, and by gosh, they all felt they were underpaid. That company ended up filing bankruptcy because they were so overstaffed, and it was a complete cluster. So, some companies have anti-nepotism clauses. The issues really arise is when you start passing it down to family members. You can create a lot of issues. So just be wary of that fact. And even if you don't have a partner and you start passing it down to your son and daughter or the 2 sons, I've seen situations where the sons got along but their wives didn't. That created issues. So just keep your eyes wide open, because many people who have their own businesses, they're not diversified. Everything they own is in that business. And presumably, at the end of the day, they need to sell that business or pass it on to their children. The problem is, though, the children may have different ideas than you have, and that business is your sole source of income. You know, sometimes when you're not ready to sell, that's the best time to sell. You've got to keep that in mind of when is the best time if you do have an exit strategy. Sometimes that strategy is, okay, I'll sell and work for the entity that buys me up. Also, I'd recommend if you sell your business, get as much cash up front as possible. And look at that note that you get in return is what my wife, who grew up in New Orleans, calls lagniappe, a little extra. So just be careful. Steve and I have represented people who have sold their companies, and they got this promissory note. They may have, if they're lucky, they get a security agreement secured by the assets, but sometimes by then there are no assets left. So just be wary. And again, when you talk about transitioning your company, think about that minority discount. Identify 1 to 3 actions you will take now to protect and maintain your business entity and plan for growth and transition. Again, respect the entity. Be careful of those intercompany debts if you've got more than one entity. You may have one entity going south on you and one entity that you've been borrowing a bunch of money on, and maybe some aggressive creditor is going to try to drag that profitable entity into the problems of the new entity. So just be careful about that. Make sure you're on the same page with your fellow investors and owners. I can tell you this, disputes between partners are no different than a divorce. I've got clients who I tell, don't sue out of principle. Divorces, you sue out of principle. You fight out of principle until you start getting the fees from your lawyer. And sometimes you still want to go. But I'm telling you, a business separation is no different than a divorce. It gets very personal. So be wary of that. What are some key concerns for businesses when negotiating commercial leases, vendor contracts, and customer contracts? Look at the default provisions. Make sure you have notice and opportunity to cure. In a commercial lease, look and see if there's a relocation clause where they can move you. You may not want to be moved. On a commercial lease, look at the operating expenses you may be charged. Get pro formas. It's not just the base rent. You also pay a pro rata share of the operating expenses. More often than not, and this is involved in either vendor contracts or leases, even though you've got an entity, you may be required to sign a personal guarantee. Maybe you have no choice. Maybe it's a loan with a bank. But maybe you can negotiate a limitation where that guarantee burns off. Think about that. When you enter into any contract, make sure you can perform. Outline specific opportunities, responsibilities. And so you and your customer or you and your vendor know specifically what each side needs to do. Because I can tell you, whether it's a lease or a contract, that's the attorney's guide if a lawsuit arises. When you're buying equipment or other assets, you want to talk to your accountant about leasing and what are your rights under leasing. Look at that lease. Leases are a form of financing. There are tax advantages to leasing. I also encourage my clients that if they're entering into a big contract or even the sale of their business where they could be tied to it, do some background checks. At the very least, you can get your lawyer to do a plaintiff defendant search in the counties in which you think this person or company does business. See how many times that company or person's been a plaintiff in a lawsuit or a defendant. Both aren't necessarily good. One's sue happy and one doesn't pay their debts. So just, those are some things to think about. In terms, the next question is do's and don'ts in collections and litigations when a customer defaults. Some customers want to sue out of principle. I represent a landlord who will sue tenants just so the other tenants know that they will be sued if they don't pay their rent or something cannot be worked out. More often than not, though, tenants break their leases because they're out of business or things aren't going well. So look at, when you talk to your lawyer, look at the cost and benefits of, okay, I've got my judgment, then what? Or, because many times, and you may have to sue, but look to settle. 80% of all cases are settled, and there's a reason for that. And I tell my clients, I've won cases I shouldn't have won, and I've lost cases I shouldn't have lost. One time I tried a case where the judge came up with a ruling that neither the opposing counsel and I ever even thought about, and thought, this is the craziest thing, I don't know where he's coming from. It's so, look at the cost benefit. Are you suing for policy? Are you suing for principle? If you're able to sue an individual as well, that's your biggest bargaining point. Litigation is expensive. And, talk to your lawyer about, what you want him or her to do. Do you want him to take a bunch of depositions? Do you want him to do a bunch of discovery? Outline that now, because everything you do in litigation is expensive. In your contracts, you may want to consider arbitration clauses. There are pros and cons to arbitration. Arbitration can be expensive, but by gosh, when that date is set for your arbitration proceeding, you're going to go. When you get a trial date with the courthouse, chances are you're not going to go the first date, but you've got to be ready. Because many times there are a number of lawsuits pending within that week. So, with that, I believe my time is close to up. Do any of y'all have any quick questions? I'll take a couple and then, yes.
Does Texas have this, what we've been reading, that